Another very important amendment is the extension of faceless mechanism to the faceless ITAT appeals. Well, friends, faceless assessments and faceless appeals schemes have already been implemented, and in line with the same, this Finance Bill 2021 contains one new subsection 5 in section 255 and authorizing the central government to notify a faceless income tax appellate tribunal scheme in line with the already introduced faceless assessments and faceless appeal scheme. Friends, time and again in all my articles and in all my discussions, I have said that no doubt facelessness can be introduced and it is a welcome step, but at the same time, the inherent principle of natural justice, that is the rule of Audi Alteram Partem, here the other side, should be inducted in this faceless mechanism in true spirits and not just for the sake of formality. Friends, nobody can deny this fact that my verbal or oral representation or explanation is more amenable to be understood by the adjudicating authorities vis-a-vis my written submissions. Even in this video, just in 5 to 10 minutes, what I am able to explain through this oral representation of mine, if I try explaining this thing in my written submission of say 10 pages, then also there is a possibility that the reader may not be able to understand what I am trying to convey. So, to take care of this basic necessity of explaining things verbally and oral representation, it is but essential to provide a by default right of video conferencing to all the assessees and appellants either in the faceless mechanism, be it faceless assessments or faceless appeals at the CIT levels or the income tax appellate tribunal levels or the faceless penalties. No doubt the physical visits are being resisted, and because of the doubts of some malpractices or corruption or personal bias. Okay, physical visits can be avoided and do away with the physical visits, but at the same time, at least these video conferencing by default right of presenting his side of the facts by virtue of through video conferencing should be made available to the assessee or the appellant in all cases, and by doing this the unnecessary litigation will also be avoided. Currently, Honorable Delhi High Court has admitted the petition in Lakshya Buddhi Raja case in faceless appeal scheme, wherein the similar issue has been made the subject matter of petition, that is principle of natural justice is being affected because by default right of personal hearing is not being made available to the assessee. So the revenue authorities will not be doing any harm to their faceless mechanism. In fact, they will be doing more justice to their faceless thought by instating a by default right of personal hearing through video conferencing in the faceless mechanism, if the assessee or the appellant so wishes. Another aspect is dynamic jurisdiction. No doubt dynamic jurisdiction is a welcome step, and the assessee's case can be assigned to any particular assessing authority or appellate authority on pan India basis anywhere based on random allocation system. But friends, having said it, the legal jurisprudence as prevailing in the geographical location of the assessee cannot be ignored in judicious disposal of the appeals, because different appellate forums located in the jurisdiction of the assessee over a number of years have formed their independent legal precedents which are binding on the assessing authorities as well as the appellate authorities of that particular region or geography. Suppose Delhi High Court has taken some view on 14A disallowance that the disallowance cannot exceed the exempt income. Therefore, this decision is binding on the Delhi ITAT. Delhi Honorable High Court decision is binding on Delhi ITAT. But now in this faceless regime, if my particular appeal is being assigned to say a Chennai based tribunal, then obviously the Chennai based tribunal may or may not be first of all know the binding decision of my Honorable Delhi High Court, because it is very practical that I, either in the capacity of tax practitioner or even the adjudicating judge, even it is very difficult for me to know each and every judgment on pan India basis about a particular issue. And in fact, I am more inclined to understand and follow over a period of time the legal precedents applicable in my region, in my location. So this dynamic jurisdiction, how this feature will gel with this in the faceless mechanism, and in this vis-a-vis the principle of legal jurisprudence, binding legal jurisprudence based on the geographical location of the assessee, needs to be taken care. So this thing should be taken care.